Hey guys, sorry for the little delay there. These things just came out, so I was kind of scrolling through a little bit before we started. So I got my kind of plan in place. We're gonna go over this tonight. We'll skim through a little bit of it. We're gonna skim over some of the like heavier law stuff, and then I'm gonna do another reading with Omar tomorrow night, where we won't like read the whole thing, but he'll talk us through the legal stuff. And then again, if you are watching this tonight and you are like, God, Lauren, you're droning on, I can't listen to this for however long, I always put out a shorter version in the morning. So please, if you can't, your attention span just doesn't like want to stick with me for 30 minutes or so, that's fine. I will be back at it tomorrow morning. So we have Justin Baldoni and the Wayfarer Party's response to Blake Lively's motion for sanctions and fees under California Civil Code Section 47.1. 47.1, we heard Asked to Lawyers, Omar, a lot of people talk about a lot, is a law in California that's supposed to um, protect survivors of harassment, abuse, sexual assault, that kind of thing, from retaliatory lawsuits by their abusers. Blake Lively has opted to try to get treble damages under this law against Justin Baldoni, which is absolute fucking bullshit. But we'll talk about why that is in a little bit. So, what's gonna happen here is we'll go over, like I said, the response, which I think was filed, sorry, by Ellen Garofalo. Followed rhymes with that. Um, and we will look at her declaration, and then, like I said, tomorrow morning I'll take another look at it, and we'll go over the legal stuff with Omar tomorrow night. We're just going to get through kind of the substance of it at the moment. So it is a little bit easier for me if I don't have the camera on right now, and I know that's been kind of an annoying thing for the last couple of weeks, but I've been having some problems. If I don't wear these glasses, I get pretty bad migraines, and it's just a whole mess. So I'm trying to kind of turn off the camera where I can. So while I'm reading, I might turn the face cam off. It's not for any reason other than I'm just trying to protect my eyes some because you can't really see, what's going on when I have these on. So I will fix it up at some point, but not right now. Um, all right, so let me pull this up real quick. Okay. Nope, I need to move my head a little bit more. That was too far. There we go. Perfect. Okay. No, it's probably better if I don't look right at you. I heard that a lot, mostly in middle school, but no. All right, let me turn off my face for a bit. You can still hear me though, so we're good. Okay. For the second time, plaintiff Blake Lively, and guys, hang on, before I get more into this, let me know, is the mic okay? Because I had to set it up a little bit. I'm not at my desk. I had to set up a different mic. So any problems, speak now or forever hold your peace. I'm going to drink some water real quick. Okay, we're good. For the second time, plaintiff Blake Lively seeks draconian relief under a new California statute, California Civil Code Section 47.1, which creates a qualified privilege for any person claiming sexual harassment under defined California statutes, including FEHA. Section 47.1 authorizes an award of reasonable attorney's fees, treble damages, and punitive damages for a failed defamation claim against a party asserting sexual harassment claims without malice, right, is important, and with a reasonable basis to file a complaint of sexual assault, harassment, or discrimination. Thus, whether the privilege and remedies afforded by Section 47.1 apply, turn not on the Wayfarer party's underlying conduct, but on Lively's motive and intent. So that's important right there. It turns on Lively's motive and intent. For example, whether Lively asserted the claims without malice and with a reasonable basis, factual issues that remain to be tried in the main case. And there's a footnote down here. It says, Baldoni's William Morris Endeavor agent Danny Greenberg Danny Greenberg testified, and then it's redacted, so we can't see it. Yeah. As explained in Section 2A below, Section 47.1's express language raises multiple constitutional concerns which have not been addressed by any California or other court, including its curtailment of free speech and a litigant's right to petition guaranteed by the First Amendment, as well as potential violations of the Fourth Amendment's prohibition against excessive penalties, treble and punitive. Further, Lively does not explain why California's presumption against extraterritorial, I think they spelled it wrong. It's supposed to be extraterritorial, yes? Extraterritorial jurisdiction does not apply to Section 47.1 when Lively is not a California resident and the alleged harassment, which is the basis for her claims, occurred in New York and on the New Jersey set where It Ends With Us was filmed. Okay. So far, so good. Lively, the statute, and its legislative history are also silent on whether these remedies are available for dismissal of a consolidated complaint. And there's a footnote 4 here. The Wayfarer party's claims were initially filed as a separate action, but have now been consolidated with Lively's complaint. And that's a question for Omar. Where the issues of liability and punitive damages have not yet been determined by the trier of fact. The extreme remedies created by Section 47.1 require factual findings that Lively asserted her claims without malice and with a reasonable basis. This inquiry turns on Lively's motives, to wit, whether her complaints of sexual harassment were made with malice and with a reasonable basis, factual determinations within the province of a jury or the court on summary adjudication based on admissible evidence. No trier of fact has made these factual determinations, which are central to the Wayfarer party's defense and will be ultimately determined in the still pending main action. Oh, by the way, Millennial Mom, thank you for the $4 super sticker. I appreciate you. Yeah. Just wanted to point that out real quick. Okay. Let's see. Hang on. Okay. So we got it turns on her motives, factual determinations within the province of a jury based on admissible evidence. No trier of fact have made these factual determinations, which are central to the Wayfarer party's defense and will be ultimately determined in the still pending main action. Although Lively contends that to be effective, the remedies should be imposed at an early stage of the litigation, which is kind of ridiculous to me, by the way. I don't know how you guys feel. Let me know in the chat, but I feel like that's ridiculous at this stage when nothing has been proven at all. And in fact, everything that she's tried to do has come up futile to enforce that this early on. That's insane. So will be ultimately determined in the still pending main action. Although Lively contends that to be effective, the remedies should be imposed at an early stage of the litigation, neither the statutory language nor its legislative history address the dismissal of a consolidated complaint before the complainant's sexual harassment claims are tried in the main action. Lively nevertheless contends that Section 47.1's remedies must be available at the earliest stage, typically through a motion to dismiss, to protect survivors from a punishing, protracted legal process. But she's not a survivor, in my opinion. And that's not what Ellen wrote here, but that's what I'm saying here. Me, Lauren, I don't believe that she's a survivor of fucking anything sexual harassment wise on this film. I can't speak to her life before that or after, but I can tell you on this film relating to Justin Baldoni, Steve Sarowitz, and Jamie Heath, I do not believe that she's a survivor of anything except for friendly interactions. Sorry, you're such a bitch. All right. Here, however, neither the dismissal of the Wayfarer party's defamation claim nor an award of penalties under Section 47.1 would achieve this statutory goal of preventing ongoing, protracted litigation over the same factual issues which determine the applicability of Section 47.1, to wit, whether Lively's claims are valid. No California court has provided guidance on this issue, including whether a court's determination before trial in the context of Section 47.1 of the complainant's motive and intent would divest a defendant of his right to a defense trial or by summary adjudication based on admissible evidence. The application of Section 47.1 to the dismissal of a consolidated complaint, while the main action is still pending, also raises the specter of inconsistent outcomes. For instance, if this court applies Section 47.1's privilege and remedies at this early juncture, what happens if a jury later finds her claims lack merit? And I believe they will. Nor has any California court explained how punitive or treble damages can be calculated without a baseline finding of actual compensatory damages by the trier of fact. I'm going to drink some water real quick. One sec. Good bitchin' lady. Thank you for the 150 super sticker. That's a nice name. Thank you very much. Have I missed Lauren using the word cunt? It's my favorite word she says. Not yet. Not yet. I haven't gotten there yet. We're working on it, though. Okay. Lively, in fact, does not directly address the key issues of her motive and intent, but deflects by recycling the full breadth of her allegation of the Wayfarer party's purported misconduct, which is the basis for pending Rule 11 and New York Rule of Professional Conduct 3.6 sanctions motions. The bulk of these allegations have no bearing on the discrete factual issues relevant to a Section 47.1 analysis, specifically whether Lively had a reasonable basis for her sexual harassment claim and acted without malice in asserting it. For instance, Lively argues that the court dismissed the Wayfarer party's defamation claim against Ryan Reynolds and Leslie Sloan for failure to plead malice, sufficient evidence of a smear campaign, and we all know about the smear campaign bullshit at this point, and strong evidence that the Wayfarer parties spread negative stories about Lively. The Wayfarer parties didn't have to do shit for negative stories to spread about Lively because Lively's behavior, past and especially present, has been enough for stories to spread. You know what I mean? So, I don't know. It's not the Wayfarer party's fault that Blake Lively was a cunt, especially when Blake Lively decided to subpoena content creators for their bank account, location data, credit card information, and all kinds of fucking shit. There was no reason for her to do that. And so negative stories spread far and wide about Blake Lively because Blake Lively is a heinous bitch. So, what does 47.1 say about that? Just saying. Okay. Whether the court found that the complaint failed to plead malice sufficient to state a defamation claim against Ryan Reynolds, Leslie Sloan of the New York Times, or spread negative stories about Lively is irrelevant to Lively's motive and intent in asserting her sexual harassment claims. And the court did not dismiss the Wayfarer party's defamation claim against Lively for failure to plead malice. Rather, the court found that Lively's complaint, the only basis for the defamation claim asserted in the cross complaint, was privileged under California's litigation and fair report privilege, and thus it was unnecessary to reach the issue of malice. So, Lively knows plenty well about the litigation privilege, right? And yet, she has tried to attack the Wayfarer parties for stuff that they put in their legal complaints recently, especially regarding the website, the lawsuit.info or whatever it is, where they have only published 2 legal documents they've written. So it's fucking stupid. Okay. One sec. Okay. Notwithstanding Lively's exhaustive rehashing of the full breadths of her allegations, the motion before the court remains short on the relevant factual issues and devoid of legal authority that might allow the court to award the punitive remedies provided in Section 47.1 at this stage of the litigation. Lively's motion should be denied because, among other things, she's a bitch. Sorry, that's not one of the points, but I'm just trying to add that in there. Lively fails to show that Section 47.1 or California Civil Code Section 3394 have extraterritorial application. Lively fails to present new facts or law that might warrant reconsideration of the court's previous denial of relief under Section 47.1. That's correct. No trier of fact has found based on admissible evidence that Lively's sexual harassment claims were asserted without malice and with a reasonable basis. So that's important right there. No trier of fact has found that Lively's sexual harassment claims were asserted with reasonable basis. Because any person with brain cells is going to see that's not a thing. You know what I mean? So Lively fails to show, and no trier of fact has found, clear and convincing evidence that malice required for punitive damages as required by Section 3294, and plaintiff has not proven, and no trier of fact has found the actual compensatory damages required as a basis to calculate treble or punitive damages. Yeesh. Okay. Hey, Celeste, what's up? How's it going? Good. Plaintiff's motion should be denied. A, no California or other court has addressed the constitutional concerns and conflicts apparent from the face of Section 47.1. And this is the one that I want to go over a lot with Omar tomorrow night. So we're gonna skim over a lot of this tonight. But plaintiff's motion implicates two California statutes: Civil Code 47.1, which applies to sexual harassment claims under certain enumerated California statutes, and Civil Code Section 3294, California's punitive damages statute. Lively seeks remedies under California Civil Code Section 47.1, which provides for severe penalties for unsuccessfully filing retaliatory defamations against sexual harassment and retaliation complainants. So here's my thought on this. And it's a valid complaint that many women who try to go up against their abusers in the legal system are unfortunately failed by that system. They can't prove it, or they can't, bring the, whatever they need to get justice that they deserve. But if you bring this law, this, as they described it, draconian law into place, like, it's also hurting people who are innocent and have never done anything to hurt anyone. So I kind of feel like it's just perpetuating the nonsense. It's perpetuating the problem. It's not really solving anything. I know that for a lot of people, they would say that Section 47.1 would protect them in certain scenarios, but you also have to prove to triers of fact that there was no malice there and all that, which is going to be a hard thing to do. So I feel like the helpfulness of that is going to be minimal, because in a lot of these scenarios, unfortunately, people who actually have committed abuses or harassment, etc., they've had some kind of relationship with the victim in the situation to where they can make it look a certain way. And also to people who are innocent and don't have those kinds of things to back up what they're saying, because they really just didn't do anything wrong and there was no reason to record everything and all that, they're also, going to get hurt. So, God, I don't know. I have so many feelings about all this. But we're going to go over that with Omar tomorrow night. So give me 1 second to drink some water, guys. Okay. Hopefully I made sense in my little rant there, but if not, we'll go over it tomorrow, like I said. According to plaintiff, the recently enacted Section 47.1 was intended to deter frivolous claims that force survivors to defend against long and expensive retaliatory defamation lawsuits by imposing significant remedies for success defendants in defamation claims. Significant remedies for success defendants successful, maybe? I don't know. And the wording is confusing me. And it was intended to protect victims from the litigation itself. Correct. Okay. As a preliminary matter, wow, I cannot talk tonight. Lively does nothing to address the constitutional concerns and conflicts raised by Section 47.1's express language. First, Section 47.1 conflicts with the right to free speech, and petition guaranteed by the First Amendment to the United States Constitution. Yep. All right. We're going to skim over that. Something for Omar tomorrow. Second, plaintiff fails to address how Section 47.1 can be reconciled with California Civil Code Section 47B, which, consistent with the right to petition, creates an absolute to bar to any defamation claim based on statements made in connection with a judicial proceeding. Specifically, Section 47B applies to any communication 1. Made in judicial or quasi judicial proceedings, 2. By litigants or other participants authorized by law, 3. To achieve the objects of the litigation, and 4. That have some connection or logical relation to the action. Okay, and a lot of this stuff is what we're going over with Omar tomorrow, so we're going to skim through that. Okay. All right. One second, I need some water. Okay. Let's see. Third, plaintiff fails to explain how Section 47.1 should, or can be applied when, as here, a defamation claim is dismissed at the pleading stage before the dispositive factual issues of whether plaintiff's claims were asserted with malice and without a reasonable basis, issues of fact within the province of the jury. And we're going to skim down a little bit. Like I said, Omar is going to go over a lot of this with us tomorrow. Where a trier of fact finds that punitive damages are warranted, the Fourth Amendment's prohibition against excessive penalties limits such damages to a maximum of 3 times the actual compensatory damages awarded by the jury. Okay. The questions of whether Section 47.1 permits punitive damages to be awarded as a matter of right, or how punitive damages would be calculated absent an award of actual damages, where a defamation claim has been dismissed on a motion to dismiss, have not been answered or even addressed by any court. Nor does plaintiff explain, much less cite authority, for how the court can calculate punitive or treble damages without an award of compensatory damages. Okay. The plethora of serious constitutional and other legal questions have not been addressed by any California court, raising the preliminary question of whether this court, as a matter of first impression, should apply Section 47.1 to impose the draconian remedies of attorney's fees, treble damages, and punitive damages without any answer to, or even guidance on, these critical questions and concerns. It may have been for some or all of these reasons the court has already declined to award Lively the relief she seeks under Section 47.1, albeit without prejudice. In so doing, the court explicitly noted that it had not ruled on whether Lively's statements were privileged under California Civil Code Section 47.1, and that if Lively chose to renew her motion, she should fully brief the impact of this opinion, if any, as well as the issues raised in prior briefing. And then they note here the court did not rule on whether Miss Lively's alleged statements were privileged under Section 47.1. One of the most infuriating things after the Wayfarer party's main claims were dismissed was that Blake Lively made that stupid fucking Instagram post basically saying that it was dismissed for being retaliatory, and basically it was dismissed on the merits, and that all these agencies who like stood up for her, one of those who at least one of them has one of her lawyers on the board, by the way, which is bullshit. Um, all these agencies stood up for her, and like they came together to protect her as a survivor and all this crap. It was insane. It was insane. So yeah. The court did not rule on whether Miss Lively's alleged statements were privileged under Section 47.1, and the misinformation out there about that is fucking insane to me, and it's so frustrating. All right. While Lively now resuscitates her motion with an extensive exposition of the facts asserted in prior pleadings in the order, she does not cite new facts or law relevant to whether she had a reasonable basis for her sexual harassment claims. She didn't, by the way, and whether her claims were asserted with malicious intent. They were. Okay. Simply put, nothing has changed since the order, and Lively and this renewed motion appears to be nothing more than an improper request for reconsideration, seemingly contrived as a thinly veiled effort to poison public perception and the potential jury pool. At best, the motion is premature, which it certainly seems to be. Yeah. All right. This court should decline Lively's invitation. Oh God! This court should decline Lively's invitation to interpret. I want to start saying that in my regular life. I decline your invitation to interpret this as such. Okay. This court should decline Lively's invitation to interpret Section 47.1 as an issue of first impression in the dearth of any guidance from a California court and impose heavy handed penalties which will require this court to make premature factual determinations. Wow. Okay. Yeah. So, mhm. Plaintiff fails to show that Section 47.1 or Civil Code Section 3294 may be applied extraterritorially. This is something we'll go over with Omar, so I'm not going to do too much of this tonight. Go down there. But let's read this part right here. Neither Lively's complaint nor the motion state facts sufficient to establish a substantial connection between the Wayfarer defendant's unsuccessful defamation complaint filed in and dismissed by a New York court or the underlying sexual harassment claim, which would give rise to the privilege she seeks to invoke. Lively is a New York resident. The core conduct, alleged sexual harassment on the It Ends With Us set, and the filing and dismissal of the Wayfarer party's unsuccessful defamation claim, the basis for Lively's request for remedies under Section 47.1 did not occur in California, but in, and then there's redactions there. I'm not sure why that's redacted, to be honest. I'm pretty sure it's either New York or New Jersey, but all right. See Ellen's declaration, which we'll look over in a second. While Wayfarer is headquartered in Los Angeles, the employee or employer's residency is not sufficient to overcome the presumption when the tortious conduct is outside California. All right. The failure to demonstrate a substantial connection between the situs of the core conduct and California defeats any notion that Sections 47.1 or 3294 can be applied extraterritorially. Okay. And again, that's more we'll go over with Omar. Because she cannot overcome the presumption against extraterritorial application of Section 47.1, Lively's request for relief should be denied. Section 47.1 cannot apply where, as here, there are no factual findings that Lively's claims were asserted without malice and with a reasonable basis. Section 47.1 creates a privilege for communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination is privileged so long as the speaker has, or at any time had, a reasonable basis to file a complaint of sexual assault, harassment, or discrimination. I guess we can stop right there then. Jeez. Okay. The Wayfarer defendant's defamation claim was dismissed pursuant to Rule 12b-6 for failure to state a claim. The order dismissing the claim expressly states that the court did not consider whether the Wayfarer parties pleaded malice, but dismissed the claim based on privilege grounds. Plaintiff's harassment claims remain pending, and the merit of those claims, as well as Lively's motive and intent in asserting them, will ultimately be decided by a trier of fact, a jury, or the court in the context of summary adjudication. Indeed, a centerpiece of the Wayfarer party's defense is that Lively's claims have no merit and were asserted for an improper purpose. The jury must resolve the threshold question of the defendant's knowledge of facts on which his or her claim is based. Plaintiffs do not explain how the court might eliminate the risk of inconsistent findings on the pivotal issue in this case, Lively's harassment claims, should this court prematurely decide that Lively's sexual harassment claims were asserted without malice and with a reasonable basis. Nor does plaintiff provide any authority for the notion that the Wayfarer defendants can be stripped of their rights to a defense at this early juncture in the context of a Section 47.1 motion. Lively similarly fails to identify new facts that might support her motion. Plaintiff merely resuscitates the allegations set forth as the basis for the plaintiff's pending motions for sanctions under Rule 11 and New York Rule of Professional Conduct 3.6. The bulk of the allegations have no relevance whatsoever to this motion, which is not about the Wayfarer party's motives or conduct, but about Lively's motive and intent. In fact, Lively's motion is laden with extraneous and irrelevant facts. For instance, Lively argues that Wayfarer's defamation claims against Ryan Reynolds and Leslie Sloan were dismissed for failure to plead malice. Lively ignores that, even assuming a pleading defect can be the basis for 47.1 remedies. The court did not base the dismissal of the Wayfarer party's defamation claim against Lively on this ground, but rather on the ground that it was subject to California's litigation privilege and the fair report privilege. Basically, Blake Lively did a damn good job of gaming the system before she brought this lawsuit. And fuck her for that. All right. The plaintiff has not proven that she is entitled to punitive damages under Section 3294. While a plaintiff who proves his case is always entitled to actual damages, a plaintiff is never entitled to punitive damages as a matter of right, not even upon the clearest proof of malice in fact. For an award of punitive damages under California Civil Code Section 3294, a plaintiff must prove by clear and convincing evidence that the defendant acted with malice, oppression, or fraud in bringing their defamation cross-complaint. And we'll go over some of this with Omar, so I'm going to skim again. The clear and convincing standard presents a heavy burden, far in excess of the preponderance sufficient for most civil litigation. Unimportant, uncreative. You're selling yourself short here, man. But says the Blake bots are all over 47.1 and claim he had no right to even respond to her allegations. If that law was mass adopted, false claims from people with personality disorders will rise. Oh, absolutely. And also, ask them how they would feel if they or their sons or their fathers, their brothers, were falsely accused. Should they not have a right to respond to their accuser's allegations? If it stands to ruin their careers, their lives. Because every single one of those people, they might pretend, they might say, just for the sake of argument, no, totally, I don't have a brother, I don't have a dad or whatever. No, fuck that. Anyone with a human heart who actually has an important male figure in their life knows that false allegations do happen, okay? And they would want their father, brother, sibling, step sibling, whatever, or their son to have an opportunity to defend themselves. So it's absolute fucking bullshit. These people's arguments are bullshit. It totally just leaves out all these important scenarios, right, that this law overlooks. And it sucks because, at the same time, there's just and I'm not denying the fact that there's so many more women who are abused or harassed or assaulted or whatever. And I'm not saying that doesn't happen, and I'm not saying they don't need protection. That's why it's so frustrating, is because there are so many people who need the help that's provided by this law. And Blake Lively is the person doing a disservice to that population. Because Blake Lively is a cunt. She was never abused. She was never harassed. She's just an entitled cunt. That's it. And if you really want to deny that, just think about the fact that she subpoenaed my bank account, my credit card number. I didn't do jack shit to this lady. I have blocked her on social media. I have blocked her fucking husband on social media. I don't want anything to do with her. I just sit here and I talk about my beliefs online like anyone else is entitled to. And she treats everybody like she's a victim. She's not shit, man. All right. The clear and convincing standard presents a heavy burden, far in excess of the preponderance sufficient for most civil litigation. We're going to skim over this and go over with Omar tomorrow. Whether a defendant acted with malice is an issue of fact for the jury, and is within the exclusive province of the jury to say whether or not punitive damages shall be awarded, and the granting or withholding of punitive damages may not legally be influenced by any direction of the court. Plaintiff simply ignores the requirements that malice be proven with clear and convincing evidence. Any finding of malice and punitive damages is within the exclusive province of the jury, and the court is prohibited from influencing the jury's decision on whether to award punitive damages. Instead, plaintiff avers that As for punitive damages, the record as it currently exists is sufficient for the court to determine the Wayfarer parties engaged in oppression. You fucking dumbass. Oppression, fraud, or malice by bringing or maintaining their claims against Miss Lively. God, what an idiot. This argument, while facile, is contrary to the law. Plaintiff fails to explain how, in the absence of actual damages, the court can calculate punitive or treble damages, and that's something to go over with Omar. So they're just asking that the court respectfully deny Lively's motion for relief under Section 47.1, which I think is absolutely fair. If you were to, at this point in the litigation, while she's proved absolutely fucking nothing in regards to sexual harassment, award treble damages. My God, that is a huge disservice to the population in general. So, all right. Sandra Hernandez says she really is a cunt. Thank you for using that word that best describes her. Well, I'll tell you what. It's not as bad now. I feel like I blocked half the internet. But when I first started talking about this case, that's a word that I use to describe people, when I feel like they're genuinely being a cunt. And so people say, like, that's misogynistic or whatever. I'm like, no, absolutely not. Because if I'm acting like a cunt, you better tell me I'm acting like a cunt. And even then, I'm going to really consider what have I been doing that's making people feel this way. And some people really do. It's just a word. It's a word you use to describe someone who makes you feel unpleasant. So just get the fuck over it. If it's like you're that sensitive to it because you're so averse to hearing the other side of the story, that's more of a problem with your inability to see both sides than it is, the actual word that I'm using. So, yeah. I suppose that's all I have to say about that. Australia uses that word for a lot of feelings, and I love the Australians. If I could, I would move there. I'm there twice a year, so I already miss it. I haven't been back since God, it was like May, June. It hasn't been that long, but still. All right, guys. I think that's about it for me tonight. Like I said, we'll go over this again tomorrow with Omar, and I'll do a little short thing tomorrow morning. But that's all I got in me for tonight. So, yeah. All right. Yes, thank you, Sandra. I appreciate it. All right, thank you, everybody, and I will talk to you all soon. Don't forget to hit the like button on this. Leave a comment for me. It helps me out a lot. I think there's like some new hype points thing. If you want to do a hype on this, that's cool. If not, I'll never know. So don't tell me. I mean, you just pretend you did. All right, thanks, guys. I'll see you tomorrow.